medical power of attorneys, and end-of-life wishes. What do most people miss? For many of you, you may think, okay, I have my medical power of attorney. I have designated who I want to make medical decisions for me if I become incapacitated, meaning if I can't make medical decisions for myself. Maybe you have a durable or a property power of attorney wherein you have designated someone or some ones to make those decisions for you. But even in the midst of that planning, I've seen seasoned estate planning attorneys and I've seen really competent people miss this precise fact: the directives to your physician. Your medical power of attorney covers who will make your medical decisions for you if you become incapacitated. But does that person really know your wishes? Do you actually have your wishes set down somewhere where he or she can know what you would do in different situations? Let me give you an example. Think about Maria Shaibo. Do you remember her, right? She was married. She was in a comatose state. The doctors say that she would not recover. Her husband wanted to unplug, but her parents wanted to keep her in the vegetative state. What would Miss Shaibo want? Would she want to be kept in that state? Think about a medical power of attorney. Could the medical power of attorney person elect to terminate her treatment even though her parents are saying, don't terminate the treatment? In that situation, if there was a directive to a physician which says exactly what she would want, guess whose rights would be paramount there? Miss Shaibo. So even from her hospital bed, even with her husband fighting to unplug, even with her family fighting to keep her in the vegetative state, Miss Shaibo could have spoken if she had that directive to physician. In your directive to physician, you can tell specifically, if I'm in a vegetative state and if my doctors determine that I'm brain dead, wherein I will not recover regardless of whatever medical treatment you give me, please unplug. Guess what? We can get that done for you. You may have a different situation wherein you are incapacitated and you're not terminal, so you're not in a vegetative state, so your brain is still functioning, but you are incapacitated and you have a disease that's going to terminate your life within the next 6 months. What would you want there? You're looking at your medical power of attorney, and your medical power of attorney doesn't speak to a situation like that. It just tells that you are designating the person to make medical decisions for you. But what directions did that person have? How does that person know what you want? The directive to physician would speak to that. I hope that answers the question for you. So there's a little bit more to be done even though you have your powers of attorney. You may want to put your HIPAA release in there. You may want to put your directives to the physician in there. So when you're doing your estate plan, remember that you're an individual and make sure you get somebody to do your estate plan who actually recognizes that. Again, my name is Megan Truick. If you like this video, please click like, please subscribe, because we try to give you helpful hints like that every day. Thank you. Hello, thank you for watching our video. And because you made it to the end of that video, we're offering you our new estate planning handbook. This is a wonderful tool and I'm sure you like it. Go ahead, download the link and let's get learning together.